Ladies and gentlemen, welcome back to the ND Zone. My name is Kathy. Many people in the public and in the press were disappointed when Judge Hippler ruled that the portion of the hearings on the motion to suppress evidence and for the potential Frank's hearing that Mr. Kohberger is seeking would be conducted in private, in a closed session. The 9:00 a.m., January 23rd, start of this two-day series of hearings before Judge Hippler on these crucial motions were behind closed doors. They were closed to the public, and witness testimony was provided at that hearing. Which witnesses? How many witnesses? What did the defense ask of the witnesses? What did the state ask of the witnesses? Did Judge Hippler have any follow-up questions? Witnesses for the defense? Witnesses for the state? The public does not know for two reasons. Number one, the witness lists that the state and the defense provided for these hearings are under seal. So the public has no notification of who was called, what their titles were. If it was a state witness, if it was a defense witness, we don't even know how many witnesses were expected to testify and who testified and what happened because the hearing was closed to the public. There is one potential way that I see, and I give my opinion under the First Amendment, freedom of speech and of the press, of the public being able to get transcripts from those hearings, potentially, big if here. If the media coalition who filed two sets of documents expressing their concern that, number one, Judge Hippler conducted a hearing that was closed to the public, as many, many hearings have been closed to the public since the beginning of this case. This one was another one that was closed to the public. It was the hearing to determine which matters would be conducted via the public realm and which would be closed to the public, and also for the court to entertain the defense's motion to have all of the filings related to the motion to suppress relative to IgG DNA unsealed and made public. The public, although we're able to see the motions, the response, the reply, the heart of what this is all about is under seal. So the defense was moving to have the briefings unsealed and to also have the witness testimony conducted as a public hearing. The court denied that motion. The court articulated the intention that the hearings where the witnesses would testify would be closed to the public. And because the witness lists for both sides are under seal, the public has no indication of who the defense called to give testimony in support of their motion, who the state called to give testimony opposing that motion to suppress. We don't even know the number of witnesses because all of this is under seal. So these are events that have come and gone. Those matters happened behind closed doors. But possibly the best way to possibly get the transcripts made public from that hearing is if the media coalition decides to once again go to the Idaho Supreme Court, as they did in 2023 when they unsuccessfully challenged the non-dissemination, aka gag order, that's been in effect in one way or another since January 3rd, 2023. And why do we have a gag order in this case that's been in effect for over 2 years now? It's because the parties went to the court originally and indicated they were stipulating to an order for a non-dissemination order, and they got it the same day. So that's what the media coalition was looking to set aside. And also the Goncalves family tried to get it set aside as well. If you've been following the case, you know that the non-dissemination order has not been set aside, and there have been so many filings that have been under seal for over 2 years now. It is stunning. So the media coalition went to the Idaho Supreme Court first. Wendy Olson represented them. It was the Associated Press was the lead member of the media, and then multiple other media organizations. That's why it's called Associated Press et al. Versus Second Judicial District et al. Et al. Means there's more people involved, more organizations involved. You have a lead party. So media coalition went to the Supreme Court of Idaho, made their pitch, and the Supreme Court said you should have gone to the district court first. You go to them first. You don't come to us first. And then if you're not able to have your issue resolved, then you come to us. But they made a big, I believe, argument and finding, the Supreme Court of Idaho did, found that the media coalition had standing. What is standing? That means you have a sufficient stake in the action to be involved in this proceeding. And as the press, under the First Amendment, the media coalition was deemed to have stake in the Idaho versus Kohberger case, at least as of 2023 when that ruling came out. So media coalition went back to district court in Latah County, and unfortunately, in my opinion, they were unsuccessful in getting the non-dissemination order set aside. The media coalition submitted 2 sets of papers this week. One set has been already made public, and I did a presentation a couple of days ago as to what that was. We also know that there was a hearing the afternoon of the 22nd before Judge Stephen Hippler, within which the media coalition gave a presentation as to why the hearings on the 23rd should be public. And that request was denied. Now we see that hearing occurred because the media coalition filed renewed papers in Ada County in the Idaho versus Kohberger case. So now what Ms. Olson did after Judge Hippler denied the request to have the hearing be public is ask for a written order so that she could discuss it with her clients. Now, typically what an attorney does if you're on the losing end of a motion, although the media coalition did get their request to be heard for one of the hearings granted, they ultimately were unsuccessful in getting the closed hearing made public where the witnesses testified. So there's a potential that they may go to the Idaho Supreme Court and at least to have the transcripts made public, because you can't go back now and unring this bell, go back in time and have this hearing again. But what they could do is potentially ask for the transcripts from the hearing, and that would be when the public might have an opportunity to learn what happened, who appeared, what was stated, and to get some more indication of what this case is all about. We'll continue to keep an eye on the docket for you for when these second set of papers get filed. We'll report back to you when they do and tell you what they said. And also we will continue to monitor if the media coalition does decide to appeal Judge Stephen Hippler's ruling of those hearings to be closed rather than open when the witnesses gave testimony. This is Kathy. Thank you as always for joining us here today.